Direct effect, indirect effect, state liability. They sound very daunting, but actually they're quite straightforward. What they're about is whether the individual can enforce a right that arises from European law. Now, the EU treaties are, like other treaties, agreements between signatory countries, and most treaties can only be enforced by other signatory countries. But within the EU, we've developed this concept of direct effect, which means that an individual can enforce the right in European law in their national courts. So if you come across a question, and these questions come up a lot in exams on EU law, about an individual and the rights they have, you'll be invited to discuss how they will enforce that right. And there are two questions you need to ask. First of all, what is the right? And secondly, does it have direct effect? So you look through, usually the question will tell you what the right is and where it arises. So you've seen this right, an individual has a right of free movement of goods, is a right to a particular document. How do you decide whether it's enforceable? Well, start off with what's called the Van Gend. Well, it looks like Van Gend, but apparently it's pronounced something like Van Gend. I apologise to any Dutch speakers for my mangling of their very beautiful language. But this criteria, clear, precise and unconditional. And what the court does is somebody asserts that there is a right in EU law, and they have to say, is it clear? Is it precise? And is it not conditional on the government doing something? In every question I've ever seen, this is nice and straightforward. If it looks like a right, then it's going to pass the clear, precise, unconditional test. Second question was, where does it arise? If the right arose in a treaty article or it arose in a regulation, then clear, precise, unconditional is sufficient. Meets that test, it is a right that you can go to your local court to enforce. But if the right arises under a directive, there are two additional things that have to be considered. Has the date for the implementation of the directive passed? Well, that's nice and straightforward. It either has or it hasn't. So if it was due for implementation on the 31st of by the 31st of December 2012, now that it's 2013, the date of implementation has passed. The one that is the issue is the next one. Is the body claimed against an emanation of the state? Originally, this was it a state body? But there are many bodies which aren't strictly state bodies that the courts take as being the state acting in one form or another. So you will come across the Foster and British Gas criteria to decide whether the body is, quote, an emanation of the state, and certainly do read the Foster and British Gas case, but the 3 points it makes is it under a statutory duty to carry out a public service? Is the service under state control? And does the body have special powers for carrying out its functions? And if those are met, it's treated as an emanation of the state, there is direct effect. Now, a lot of questions actually are not as clear enough that you can say definitely. So if you've ruled out direct effect, or you've said, well, we can't be absolutely certain, you'll then move on to the question of whether indirect effect may help. Now, this is where the national court interprets the national legislation in such a way as to give effect to the European Union right. And as long as it can do that without actually doing violence to the language of the national statute, then there can be indirect effect. Again, there are certain circumstances where the only way you could interpret it would be to add the word not. That's too far. Then indirect effect will fail. And you need to consider the third remedy. Now, this is different. The first two remedies are cases brought against the body whose decision you are complaining about. So if my rights as a worker have been denied by my employer, you will take the case against your employer in the national courts and you'll argue direct effect or indirect effect. If those two aren't available, then you can take an action, again in the national courts, against your national government for state liability. They had a duty to you to make this right available and they failed to do so. What you need to look at here, again, are three criteria. Is it an infringement of a rule of law intended to confer rights on individuals? Is there a sufficiently serious breach? Now, the Dillon-Coffer case suggests that failure to implement the directive at all is in itself a sufficiently serious breach. So if they haven't implemented at all, it passes the test. If they have implemented but improperly, then you'll have to consider whether it is, quote, manifest and grave breach. And the sort of things will be the clarity and precision of the rule breached, how much discretion has been left to the member states, and so on. And the final thing you have to show is that there is a causal link between the person who's claiming and their loss and the failure of the state to implement the appropriate legislation. So direct effect, indirect effect, state liability, they're all about rights arising under European Union law. Thank you.